The liberal definition of what constitutes an assault-style firearm has changed over the years. But if we look back to the criteria established when they banned these so-called military-grade assault weapons in the 2020 OIC, does it still hold up? Let's have a look. Welcome back to the channel. So today we're going to be continuing our CCFR versus Canada series. In our previous video in the series, we took a look at what constitutes an assault-style firearm. In that video, we built a new definition from the ground up to really explain what it is and what it isn't, as well as to showcase how Justice Kane actually had enough information to come to that same conclusion on her own. However, that definition would contradict the sloppy and inaccurate criteria as set forth in the Order in Council's Regulatory Impact Analysis Statement, otherwise known as the RIAS. It also forgets the most important part of the debate, which is something that Justice Kane got distracted from as well during the case. What an assault-style firearm is or isn't is mostly a non-issue. What it is isn't important. What it does is what's important. It is the claim in the OIC that these firearms are unreasonable under Section 117.15 of the Criminal Code for hunting and sporting purposes because they're dangerous and therefore they're unsuitable for civilian use. The issue is not at all about whether or not some firearms are or aren't assault-style firearms. The issue is actually about whether or not these so-called assault-style firearms are actually unreasonable and actually exceed safe civilian use. So unlike my previous videos so far where we have discussed the case and the ruling from Justice Kane, in this video we are primarily going to analyze exactly what the OIC says about the rationale laid out within it in order to completely destroy it beyond any reasonable doubt. To keep it fair, we are going to be using the same standard they also used in the case, which is the reasonableness standard as established in Vavilov. According to the Ontario Superior Court's Guide to Judicial Review, they have this to say about the process of determining reasonableness. So they say that reasonableness is a deferential standard of review. A reasonable decision is based on internally coherent reasoning, and is justified in light of the fact and law that constrain the decision maker. The reasonableness standard recognizes that there may be more than one reasonable interpretation, or more than one reasonable possible result. On this standard, courts will not interfere with decisions that they consider reasonable, even if the judges themselves might have come to a different decision. When a court applies the reasonableness standard, the person applying for the judicial review has to persuade the court that the decision was unreasonable. A court will find that a decision is unreasonable if there are any fatal flaws in its overall logic or if it does not respect the factual and legal constraints on the decision. So when analyzing the various objectives and rationales within the OIC, we will need to prove that it lacks internally coherent reasoning and that the relevant factual and legal evidence do not support its claims. It will also not be enough to only show that there was a better way or that there were better alternatives, but rather that their interpretation was nonsense or somehow inadequate to begin with. I mean, this is a pretty tall order, but I think it's doable. Most of the justifications and explanations laid out within the RIAS are fairly poor and minimally thought through, but effectiveness isn't really something we can address under the reasonableness standard. So the common argument that we always make that, it'll only hurt us and not do much to combat crime, isn't even really a relevant factor under the reasonableness standard, even though it's a completely true statement. We would have to go so far as to prove that it will help absolutely zero people, or that banning firearms would somehow increase gun violence or violent crime. And while there are a lot of charts out there from various countries around the world which would certainly indicate some substance to these claims, there are also a lot that do not. And both of these charts are merely correlation statistics and do not rise to the level of factual evidence or concrete proof. Any judge operating under this standard would be required to simply rule that determining which charts are more correct or more accurate is the job of Parliament. However, there are two areas in particular which I think could rise to a level of unreasonableness. Now, first off is the blatant misinterpretation of the actual OIC powers granted under Section 117.15 of the Criminal Code. But that's going to get its own video up next in Part 5 of the series, so I won't discuss it too much in this one. But that is likely the thing which the CCFR will use to overturn Justice Kane's decision in their upcoming appeal on December 9th and 10th in Ottawa. So our remaining talking points regards the factual and legal constraints on the government's criteria for what makes assault-style firearms unsuitable for civilian use. The various claims in the RIAS are that these firearms are somehow inherently dangerous, or that they can cause harm, and that alone makes them unsuitable for civilian use. Now that criteria alone would be vague and difficult to criticize, But fortunately, the government gave us some very specific talking points about what makes these firearms actually unsuitable. And not only that, but they actually said it multiple times in the Reas, so we can be sure that this is the core justification for the firearms on the list. Reading directly from the Reas, it says, the regulations have been amended to prescribe as prohibited approximately 1,500 models of firearms. Of those, 9 principal models of assault-style firearms are prohibited as they have a semi-automatic action with sustained rapid-fire capability, which means they have a tactical or military design with a large-capacity magazine. Secondly, they are of modern design. And thirdly, they are present in large volumes in the Canadian market. So I'm going to analyze these 3 criteria in reverse order, asking if these criteria are reasonable considering the factual and legal constraints on the government's decision. So first off, the government says that these firearms are to be banned because there's too many of them in circulation. This is even specifically explained in the Reas in multiple places. So now we ask the question, is this reasonable from a legal perspective? And the answer is actually more contextual than you would think. One of the mistakes Justice Kane regularly makes throughout her ruling is that she considers Cabinet to be on par with Parliament. But it's not. Not really, at least. The regulations that Cabinet can promulgate are not lesser in any way, but what they can do and what jurisdiction they have to act is significantly more restrictive and narrow than the legislation enacted by Parliament. Had the government proposed a bill in Parliament and had it go through 3 readings in both the House and the Senate, and then off to the Governor-General to receive royal assent, then yes, this would be reasonable criteria for which to ban firearms. Now, I don't mean to alarm anyone, but Parliament has an almost limitless amount of latitude and leeway to enact nearly any law or statute in the name of public safety. Had this OIC not been an OIC, but rather an act of Parliament, we really wouldn't have much of a leg to stand on. However, this is not an act of Parliament. This is an order in council. This order in council is bound by the statutory authority which gave them the power to prescribe. And even if we use the government's perverted interpretation of their authority under Section 117.15, the power here is very clear. We aren't technically asking whether or not these measures will help public safety. We're still asking whether or not these firearms are reasonable to use for sporting or hunting purposes, even though the government has wrongfully interpreted this threshold as inherently dangerous. Now, Cabinet cannot use the authority that they do not have to promulgate regulations, even if they claim their intentions are pure. And therefore, public safety is only relevant to us in this case if the proposed characteristics or capabilities are real, and if they actually relate to a firearm's dangerousness. This is even backed up by the clearly stated objective in the Reas, where they say, the prescribing of firearms as prohibited is intended to limit access to firearms that are characterized by their design and their capability of inflicting significant harm to Canadians. So now that we know the legal context, we have to ask the factual questions. Does having more firearms make a particular firearm more dangerous? And the answer is no, of course not. Like, for example, take this rifle. Certainly very assaulty looking, very scary looking. If I had another one of these sitting on the floor next to me, would the characteristics or capabilities of this one be enhanced as a result? Of course not. What if I had 100 of them scattered about this room? Would that make this firearm more powerful? What if I had 1,000,000 of them scattered about all over the place? Would that realization suddenly alter this firearm in any way to make it more dangerous than it was before? Of course not. That's a completely ridiculous idea. And not only that, but if we consider for a moment firearms which would actually be reasonable for hunting or sporting purposes, then you should expect people to own those in higher numbers. It's entirely reasonable to suppose that the more effective a particular firearm is for hunting or sporting purposes, the more that firearm should expect to sell. Its popularity is actually directly a testament to its reasonableness for hunting and sport. And this was even brought up to Justice Kane in paragraph 243 of her ruling by the Généraux applicants, but as near as I can tell, it wasn't even addressed by Justice Kane beyond that. Which, I mean, that's pretty par for the course in this ruling. She displayed quite the habit of dismissing anything which could have hurt the government's case. And all of this means that from a factual and legal perspective, the concerns of some firearms being present in large volumes is irrelevant to the nature of what makes a firearm unreasonable for hunting or sporting purposes. And this kind of irrelevance actually has a name in the law. It's called arbitrariness, and it's usually indicative of a charter violation under Section 7. Now, such violations can still be justified under Section 1. However, since we're not talking about the charter here, but rather the nature of the powers given to Cabinet in Section 117.15 of the Criminal Code, The more appropriate remedy would be to strike this reason from the RIAS as a legitimate justification for what makes assault-style firearms unreasonable for civilian use. So now if we just strike down the other two parts on this list, we should be able to show rather clearly that the underlying rationale of the OIC is deeply flawed, and therefore it's not reasonable under the Vavilov standard. And speaking of arbitrariness, next up is the criteria of modernity. Now this one is pretty difficult to determine its legal origin since there isn't really any kind of legal definition anywhere for what that means, nor is it explained in the RIAS. However, the threshold will be the same. Does a particular firearm's modernness make it unreasonable for hunting or sporting purposes? Does a firearm's modernness directly translate somehow into enhanced capabilities or increased dangerousness? And this one is also fairly simple to prove. Without a legal definition, we're going to go to a dictionary definition. And Google defines modern as relating to the present or recent times as opposed to the remote past. Works for me, so let's grab a rifle from recent times and one from the remote past. To keep things as apples to apples as possible, we're going to grab two bolt-action rifles. Neither of these would qualify as assault-style firearms, but that's not actually the claim being made here. The claim is that modern firearms are somehow inherently more dangerous or more harmful than the older ones, thereby making them unsuitable for civilian use. So, let's see if that's true. First up is our modern firearm. This is a Tikka T3X, or more specifically a Tikka T3X Lite. It was designed in 2016, and it shoots 6.5 Creedmoor. This is a cartridge which was designed in 2007. So whether you want to measure it by the rifle or by the cartridge, this is a very modern combination. There would not be many rifle and cartridge combos which would be more modern than this. It has a nice lightweight stainless barrel, a modern polymer stock, and a detachable magazine with a capacity of 3. So what about our ancient rifle? Well, this is a Lee Enfield. It is a bolt-action rifle which can trace its origins all the way back to the late 1800s. However, if we're being fair, this is actually the Mark III, which was originally manufactured in 1907. There are not many magazine bolt-fed action rifles which would predate this one. It has a standard barrel, a heavier sporterized wooden stock, and a detachable magazine with a capacity of 10. Being that it is a bolt-action rifle, it has an actual legal capacity of 10, which means no need for pins or other limitations. And it shoots the somewhat outdated, but plenty powerful 303 British cartridge, which was first manufactured in 1890. So let's put these head-to-head to see if modern rifles are more dangerous than non-modern rifles. As we already established in Part 3, the 3 criteria which determine a firearm's capabilities are its fire rate, its ammo capacity, and its lethality. Comparing these two rifles, their fire rates are about the same since they're both bolt-action rifles. Ammo capacity is a clear winner to the Lee Enfield, as the Lee Enfield has a double-stacked magazine which can hold 10, while the Tikka single-stack only holds 3. And what about lethality? The OIC actually gives us some guidance on that. The government said that any firearm which has over 10,000 joules of muzzle energy is unsuitable for civilian use. Since the government seems game to use this as their standard, we're going to use it as well. According to the wiki, 6.5 Creedmoor has a muzzle energy of around 3,000 to 3,200 joules, whereas 303 British has closer to 3,500 joules. And this slight difference is more academic than anything, but the edge does go to the 303 British in terms of lethality. So, are modern firearms somehow more powerful or more dangerous or less suitable for civilian use? No. I've only shown one pairing of rifles here, but this is hardly an unusual circumstance, and disproving it even once should be enough to disprove the claim outright. And this shows us ultimately that, as with the popularity of firearms, the modernity of a firearm is wholly unrelated to its capabilities or to its dangerousness. So once again, we'll strike this criteria off the list for being arbitrary. And last up is the criteria that assault-style firearms are capable of sustained rapid fire. And there will be no arbitrariness to be had here. This concern is directly linked to the claims that some firearms may be more dangerous than others. So, we take a different approach. Do these firearms even have said characteristics or capabilities? Are assault-style firearms actually capable of sustained rapid fire at all? The answer is not as obvious as you might think. And this question can actually be broken down into two separate parts. Are assault-style firearms capable of sustained fire? And are assault-style firearms capable of rapid fire? So first off, what is sustained fire? Well, during his tenure as Minister of Justice, David Lametti was part of the launch of C-21. And during that press conference, he gives us a pretty solid definition to go on.
Possession of an overcapacity magazine is already a criminal offense because these magazines pose a public safety risk. They enable sustained fire with less frequent reloading.
So, it means a large capacity magazine. This is also very clearly spelled out in the Reas in the parentheses. It's also an intuitive definition, so it really doesn't need much more elaborating than that. However, did you catch the other part of what he said? Such magazines are already prohibited. It's a criminal offense to even have them. They've been prohibited for a very long time in Canada. Now, to be clear, Cabinet would have the authority to ban them through this OIC if they wanted to. That's not up for debate. And they could easily do that by prescribing them as a prohibited device. The issue here is that these magazines were already banned decades ago. So them saying that they need to ban these magazines negates the concrete legal reality that these magazines have been banned for a very long time. Now, you might be able to argue that they were concerned about circumventions, but despite what the government tried to bring up through Professor Brown during Justice Kane's ruling after the fact, the OIC itself actually makes no mention of this. Additionally, if they were actually worried about the circumventions made potentially possible by limitations such as pinned magazines, then they have the ability to prescribe magazines as prohibited devices, as well as prescribing different lawful limitations, or removing them altogether so that magazines can never hold more than their prescribed capacity. The government has actually even made this promise several times, but as of yet they have not done so. Additionally, as I very clearly articulated in the last part of my series, both in my own words as well as in government expert Mr. Smith's words, magazines are wholly unrelated to any firearm status as an assault-style firearm. And this is because even civilian-style semi-automatic firearms, like the Browning Bar, are completely compatible with larger capacity magazines. You might be able to argue that they are concerned that individuals may source large capacity magazines through some alternative matter, such as smuggling or 3D printing, and for what it's worth, that's not an entirely unrealistic concern. But if that's the threshold, then every magazine-fed firearm on the planet is compatible with large capacity magazines, and therefore every mag-fed firearm becomes an assault-style firearm, resulting in an overbroad interpretation. Now there is one hiccup here though. Since we're operating on the reasonableness standard, it's worth remembering that things like efficiency or effectiveness are basically unimportant. Even though there are more sensible ways to handle the issue of magazines, that, in and of itself, doesn't require the government to pursue those options. However, there is one thing that does, and that's the statutory powers which are supposedly being used here to ban firearms under Section 117.15 of the Criminal Code. The overbroad nature of the concerns regarding magazines would lead to either the banning of firearms which are actually reasonable for hunting and sporting purposes, or, if they don't intend to go that far, then they are only talking about magazines which have already been legally banned. So addressing the magazine problem either requires absolutely no action, or an extreme overreaction which couldn't be justified under Section 117.15. Now I gotta be honest, if you took that argument before a judge, they would probably stop listening as soon as the words large capacity magazine left your mouth. So it's a decent argument, but honestly, it's probably unlikely to work. However, it doesn't actually need to. Remember, the criteria was actually sustained rapid fire, not just sustained fire. If we can win on the definition of rapid fire, that would be enough to also void this section. So what does the relevant law say about rapid fire? Well, it says, this is where we win. The law is very clear about what rapid fire is. There are definitions in several places of the law as well as Supreme Court precedent which I'm going to use to pick this nonsense apart. So let's start with the factual constraints this time around before we get into the legal ones. So the RIA says assault-style firearms have a semi-automatic action with rapid-fire capability. The RIA also says that this is the result of their tactical or military design. Then it stands to reason that semi-automatic firearms which do not have a tactical or military design are not capable of rapid fire? Are some semi-automatic firearms more semi-automatic-ier than others? Are black scary rifles capable of higher fire rates than non-black scary rifles? During Justice Kane's court case, the government expert Professor Brown doubles down on this nonsense claim, stating that this is the result of design following function. But where does he get this information? Because it's not stated anywhere in the court case. Well, according to Professor Brown's affidavit, which was supplied online by the CCFR, thanks for that guys, he says that an assault-style firearm is a semi-automatic rifle, among other things, and then he also goes on to say that this term can be used interchangeably with all sorts of labels. And they're often referred to as paramilitary rifles, military-style rifles, modern sporting rifles, black rifles, assault weapons, and assault rifles. Now, I don't know what kind of expert he thinks he is, but assault weapons aren't a real category of firearm. Yet it is often used by the ignorant to refer to assault rifles, which are a very real thing. And assault rifles are capable of automatic fire, among other criteria. So he says that assault-style firearms are semi-automatic firearms, and even the OIC says they're semi-automatic firearms, but then he goes on to say that it's fine to call them automatic firearms. Now this might actually be dismissible since he says that's how they're often referred to, indicating that maybe he himself doesn't actually believe that, except for what he says next. So he goes on to say, critics of prohibitions on assault-style firearms frequently claim that these guns were regulated simply because they had a supposedly threatening appearance. However, American writer Tom Diaz has emphasized that the look of assault-style rifles is not cosmetic, but it is, rather, designed to ensure that the person wielding the firearm can discharge it quickly and accurately. Quote, the assault weapon's physical appearance is the result of design following function. All assault weapons, military and civilian alike, incorporate specific features which were designed to provide a specific combat function. That function is laying down a high volume of fire over a wide killing zone, also known as hosing down an area. Civilian assault weapons keep the specific design that makes this deadly spray firing easy. In the same paragraph, he says semi-automatic assault-style rifles aren't just cosmetically different, because some dude wrote a book about fully automatic assault weapons says that they're capable of high volumes of deadly spray firing. Which means Professor Brown deliberately conflated those two categories together solely because of how they looked, not because of how they functioned. One is a semi-automatic firearm, and the other is a fully automatic firearm. So not only is the statement wrong, but it actually entirely proves our point. How Justice Kane even allowed this man in her courtroom after swearing an oath to that statement is, frankly, it's kind of beyond me. But not only that, she actually used this as part of her decision for why these firearms are dangerous. Once again, proving a bias. But let's give her the benefit of the doubt here. After all, Professor Brown is the expert. Maybe Justice Kane really isn't all that well versed in the lingo and really doesn't understand what he's saying. Not that that should be any excuse, but hey, we're all human. We all make mistakes. Professor Brown, on the other hand, he is the expert. He should know better. But what kind of expert is he? He claims to be an expert in the history of firearms use and regulation, and he has even taught advanced classes at universities to this end. This was right up his alley. So either he's not the expert he claims to be, or he intentionally perjured himself to help the government out. In either instance, his testimony really should be discarded. Like, he can't be trusted after that. Oh, and by the way, totally unrelated note, I'm sure, he has received funding from the government for his firearm research. Yeah, not even making that up. So, Professor Brown, Mr. Historian of Firearms Regulation, let me show you what the law actually says in regards to rapid-fire firearms. In Section 84 of the Criminal Code, it says this: automatic firearm means a firearm that is capable of, or assembled, or designed and manufactured with the capability of, discharging projectiles in rapid succession during one pressure of the trigger. So rapid fire shows up in the definition of an automatic firearm. Not looking good for you, bub. Next, we take a look at the definition of semi-automatic, and it makes no mention of any kind towards any sort of fire rate, let alone rapid fire. But to be fair, it's worth mentioning that this is a new definition which was added to the Criminal Code with the passing of Bill C-21, and therefore it wasn't available at the time that the OIC was enacted. And the Liberals also had every opportunity to add the words rapid fire if they wanted to this definition. But that being said, this alone doesn't prove that semi-automatic firearms aren't capable of rapid fire. But this does. In the regulations prescribing certain firearms and other weapons, components, and parts of weapons, accessories, cartridge magazines, ammunition, and projectiles as prohibited or restricted, do you know what it says? Under the list of prohibited devices, it has a section referring to the banning of things like bump stocks, forced reset triggers, binary triggers, and so on. And pay attention to the specific wordings they use. It says, any electrical or mechanical device that is designed or adapted to operate the trigger mechanism of a semi-automatic firearm for the purpose of causing the firearm to discharge cartridges in rapid succession. And if you recall, discharge in rapid succession is the exact same phrasing used to define an automatic firearm. Rapid fire means automatic fire. And this section of the law says, very clearly, that semi-automatic firearms are not capable of rapid fire without enhancement from an electrical or mechanical device. Someone who claims to be an expert of firearms regulation really ought to know this. Oh, and, since we're here, know who else ought to know this even without expert help? The government. Because you want to know what else is on this page with all these prohibited devices? The entire friggin' ban list. So all of the regulations from the OIC get registered on the schedule on this page. So it's not like I'm bringing up some old musty tomes from ancient records in the back of the library or something. Like the OIC regulations and the statute to disprove the RIAS are literally on the very same page. So, yeah, very frustrating. The OIC claiming that these semi-automatic firearms are capable of rapid fire is ridiculous. The firearms on this list were not automatic firearms like the military used. And despite contradictions in Professor Brown's affidavit, he even admitted to this. So not only is he ignorant or a liar, he can't even keep his story straight. And this again speaks to the integrity of Justice Kane's ruling. There's been lots of questionable topics all throughout that she just didn't get to the bottom of for no discernible reason. All of these particular points aside, there is one more glaring issue with the overall rhetoric and claims in the RIAS. Like, maybe you're still not on board. Maybe you think my arguments have been weak thus far. Maybe you're not all in because I'm not actually a lawyer, so what could I possibly know? Well, you don't have to believe me. Believe the Supreme Court. Believe it or not, the Supreme Court has already ruled on this, albeit indirectly. There is precedent which would support my claims and the claims of the applicants. Precedent which would directly bring the government's assertions into question. Precedent which says that our semi-automatic modern sporting rifles are not military-grade armaments. They're not designed for military use. That they're not designed to kill the largest number of people in the shortest amount of time, despite what the Liberals would claim. The case in question is that of the Crown versus Hasselwander. I've discussed it briefly on the channel before, and it was also brought up in Justice Kane's ruling, although for different reasons. But this is the case where the Supreme Court actually really clarified where the line is to be drawn between a semi-automatic firearm and fully automatic firearms, particularly as it related to a semi-automatic firearm's capability of being converted into a fully automatic firearm. So pretty relevant to our conversation here, don't you think? Now, before I get into what the Supreme Court said, I want to remind everybody once again what the government says about our semi-automatic sporting rifles, and I'm going to quote it directly from Justice Kane's ruling to show that she is also on board with it. So she says, the RIAS elaborates on why assault-style firearms are not suitable and not reasonable for hunting or sporting purposes, emphasizing that the significant risks posed to public safety outweigh any justification for their use in hunting and sport. So the RIAS states, assault-style firearms are not suitable for hunting or sporting purposes given the inherent danger that they pose to public safety. The newly prescribed firearms are primarily designed for military or paramilitary purposes with the capability of injuring, immobilizing, or killing humans in large numbers within a short period of time based on the basic characteristics they possess, such as a tactical or military design and capability of holding a quickly removable large-capacity magazine. While some of these newly prescribed firearms were previously used by individuals for hunting or sporting purposes, it is the view of the government that those firearms are unreasonable and disproportionate for such purposes. This significant risk that these firearms pose to public safety outweighs any justification for their continued use. Now, surely that's not news to anyone. The government has been saying all of this for years now, and this rhetoric is iterated a great many times in small variations throughout the RIAS and in Justice Kane's ruling, as I've demonstrated many times throughout the series. So I'm going to leave that on screen while I read the quote from the Supreme Court, because what comes next is almost comical. You remember like when you were a kid and your buddy didn't do his homework, so he asked if he could copy yours? And, of course, being a good friend, you told him, sure, you can copy your homework. Just don't make it too obvious, otherwise the teacher will know. That's basically what happens here. So as I read the Supreme Court decision, I'm going to be highlighting the related parts of the RIAS to show just how much overlap there is between what the Supreme Court said about automatic firearms and what the government claims about our semi-automatic sporting rifles. So the Supreme Court said, let us consider for a moment the nature of automatic weapons. That is to say, those weapons that are capable of firing rounds in rapid succession during one pressure of the trigger. And there's that term again. So even the Supreme Court agrees that rapid fire means fully automatic. They continue by saying, these guns are designed to kill and maim a large number of people rapidly and effectively. They serve no other purpose. They are not designed for hunting any animal but man. They are not designed to test the skill and accuracy of the marksman. Their sole function is to kill people. These weapons are of no value to the hunter or to the marksman. They should be used only by the armed forces and, in some circumstances, by the police forces. There can be no doubt that they pose such a threat that they constitute a real and present danger to all Canadians. There is good reason to prohibit their use in light of the threat which they pose and the limited use to which they can put. Their prohibition ensures a safer society. And that's rather curious, isn't it? How remarkably similar those two descriptions are. Shocking might be a better word than curious. Now, you might be able to chalk this up to a difference of opinion, or you might be able to argue that just because there's some overlap in these definitions doesn't mean that one should trump the other. But actually it does. The Supreme Court used one very deliberate word which makes such counter-arguments invalid. Nature. The Supreme Court was discussing the nature of automatic firearms. Nature is defined as the basic or inherent features of something, especially when seen as a characteristic of it, which, curiously enough, is also what the government chooses to focus on in the Reas. Characteristics. So the Supreme Court wasn't just describing what automatic firearms can do, they were describing what the inherent characteristics of automatic firearms are. Meaning that they aren't just saying that automatic firearms are these things, but also that if you are these things, then you must be an automatic firearm. And given the content of the court case, one would not be able to argue that I'm somehow taking this out of context. Like, it would not be possible to argue that the Supreme Court somehow failed to consider how such a definition might overlap with semi-automatic firearms, since the entire focal point of the case was the mechanical and functional delineation between semi-automatic and automatic firearms. They absolutely would have considered how this criteria for what constitutes the nature of an automatic firearm might have affected the nature of a semi-automatic firearm. And not only that, but it should be assumed that differentiating the characteristics of automatic firearms from semi-automatic firearms is entirely the purpose of this paragraph. There would be no other reason for them to bother bringing it up in the first place. And this is also evidenced by the fact that the Supreme Court opted to not mention anything about other potentially harmful criteria, such as magazine capacities, during their definition. And this is because magazine capacities are not inherently part of the nature of an automatic firearm. A firearm does not become less automatic simply because of a larger or smaller capacity magazine, and capacities of any size are compatible with all types of firearms, not just automatic ones. So, according to existing statute and Supreme Court legal precedent, there can be no such thing as a semi-automatic rapid-fire rifle. So either the Reas is talking about semi-automatic firearms and it contradicts existing legal statute and Supreme Court precedent, or it is talking about automatic firearms, in which case most of the firearms on this ban list shouldn't be there. In either interpretation, a court should not be able to find such criteria reasonable for the basis of banning semi-automatic sporting rifles under the regulatory powers given by Section 117.15 of the Criminal Code. So there you have it. Even without any additional evidence or testimony from the applicants, the OIC doesn't even stand up on its own. It completely fails to uphold any semblance of factual or legal coherence, and the information presented in this video is far from its only shortcomings. This really proves beyond any doubt that the government is trying to convince everyone that our semi-automatic sporting rifles are the same as military-grade assault rifles. But that's not a reasonable assertion when you look at the relevant facts on law. The information regarding the legal definition of rapid fire as related to the precedent of the Crown versus Hasselwander doesn't appear to have argued by any of the applicants so far as I can tell. But I'm of the mind that there's a pretty strong difference between colloquial use of the word and legal use of the word. Like, it might be fine and dandy to say rapid fire in a casual conversation between two friends, but in a courtroom, these words have meaning. The law hinges on definitions, and this one should be no different. But who knows? Maybe I'm wrong. Maybe I'm grasping at straws. Maybe making a stand over this definition of rapid fire is a weak argument. That being said, the arguments against modernity and popularity being relevant were brought up, and they don't appear to have been properly considered by Justice Kane in light of the powers given by 117.15 of the Criminal Code, which is what we'll dive into in our next part. We'll finally bust this whole thing wide open, and I will show beyond any doubt why Justice Kane was wrong to rule the way she did, and why we're about to get our rifles unbanned once the Federal Court of Appeals hears the case again on December 9th and 10th in Ottawa. At least, if they give us a fair shake anyway.